Thank you, Your Honor.
All right. On this motion, parties ready to proceed. Let me address one matter that I think would be appropriate to address first, and that was a motion with regard to the testimony of Ms. Holmes herself. The state had filed an objection. There's no motion to quash because I don't think there was a subpoena. There was some discussion, so I don't think a motion to quash would have been the appropriate vehicle. So it looks like the state filed a motion objecting to her being called as a witness.
Yes, Your Honor, we did.
All right. Do you intend to call Ms. Holmes as a witness?
At this point, I don't intend to. I spoke with Mr. Evans, I believe, about this subject, not Mr. Uncast, and I apologize, I wasn't aware of the division of labor for today's hearing. I would not anticipate wanting to call her as a witness. If I did, I would certainly notify the court, but I don't see that happening today. We have Mr. Tom Durden, our Liberty County District Attorney, and the Deputy Assistant Attorney General, Mr. McGowan, I believe, who has been identified by the Attorney General's office as the individual in their office most familiar with the appointment process in this case. I don't anticipate any other witnesses.
That is correct, and Your Honor, the state objects to this entire motion. The basis for that objection is that the defendant actually has absolutely no standing to bring this motion. Ms. Blair McGowan from the AG's office is here per agreement with Mr. Goff because he withdrew his subpoena on Mr. Chris Carr, and Ms. McGowan is the person who actually is in charge of that particular unit that reassigns district attorneys who recuse themselves, and Mr. Durden is also here. However, at this point in time, the state objects to this entire motion, given that both Mr. Bryan lacks standing, and in addition, this court has absolutely no authority to either grant or deny the motion.
Let's get into that, because I'm trying to, I've read through the briefs. What I understand this to be, and Mr. Goff, you can address this, I guess, first, is this is the defendant's challenge to Mr. Durden's representation that he had a conflict of interest.
In a roundabout way, that would be true, but what this really is ascertaining who is the district attorney lawfully prosecuting this case. Our contention is, under Georgia law, that Tom Durden remains the district attorney prosecuting this case. And if he is the district attorney prosecuting this case, then he should be prosecuting it, not somebody else.
Well, isn't that a question of law?
I'm sorry?
Isn't that a question of law? Isn't that simply Mr. Durden, as I understand it? And there's some additional documents that the court receives some notice of that's possibly being used in this motion here. But what I had associated with the motion was Mr. Durden's letter to the Attorney General's office indicating he was recusing. And that recusal was based upon the fact, as I understand it from the letter, and I understand nobody's objecting to the authenticity of the letter.
No objection.
So the letter indicates that Mr. Durden was assigned the case through the statute, that once he was assigned the case then, my words, not his, morphed into something a little bit different. It expanded. It became more than the murder investigation, but then also started involving some other aspects. And again, from what I understand, simply by reading the letter, he then indicated he didn't have the resources to do that, didn't realize what it was, and because of that, he had to recuse. I don't understand how that isn't a conflict of interest under the Georgia rules. And so I'm trying to understand what this is really a fight over.
And those are legitimate questions. And I know the court's read my motion, and I know the court's read the state's response. And we are in uncharted territory, with all due respect to the state. The two cases they cite involve solicitors, not district attorneys. District attorneys are constitutional officers. Most counties don't have a solicitor.
Let's get past that. And I agree. The statute that was addressed in the case that's cited, I can't remember the name of the case off the top of my head. Mantooth. I think Mantooth is the case everybody's talking about when it comes to standing. Mantooth addresses the solicitor. That statute's a little different. It's passed a little bit after the prosecutor statute. Fair. Okay. Let's pretend for a moment that we're not going to argue. Well, not pretend. Let's not argue that for a moment. My question about this motion, which gets to the standing issue, was this is a lawyer saying they have a conflict of interest. This is a challenge to the legal process. This isn't a statutory challenge. This is simply, as I understand it, the defense challenging Mr. Durden's claim that he has a conflict of interest sufficient to trigger the appointment of a new district attorney pro tem.
That's not a fully accurate summary of our position. Our position is this, that as a government lawyer and a constitutional officer, the responsibilities and duties of a district attorney are different than that of a private lawyer, number one, in that unlike a private lawyer, the district attorney has an office at his disposal and all kinds of ways to get resources when they're needed to handle a case. Our position is the district attorney doesn't get to pick and choose which cases they want to prosecute on the ground that they're too busy or they don't have enough resources. There are ways to address that, and as a government lawyer and a constitutional officer, the bar rules must be applied in that context, and that's a very different context. But the second point is the statute itself does not give the Attorney General the unqualified authority to appoint in the event of disqualification. The Attorney General's authority is limited by the statute itself, and the statute itself limits the Attorney General's authority to make an appointment to quote-unquote interest or relationship. If the district attorney does not have an interest in the matter or a relationship to someone in it that would be disqualifying, then the Attorney General doesn't have the authority under that statute to make the appointment. Now, who does have that authority would be unclear. Historically, it seems that courts have taken up disqualification issues and have appointed people. Granted, those are mostly solicitor cases. But the argument here is that the Attorney General's authority is purely statutory because we're talking about a constitutional officer. Outside of that statutory authority, the Attorney General can't make an appointment. So, if the reasons provided by Mr. Durden why he wishes to get out of the case, regardless of the bar rules, if the reasons provided do not meet the statutory requirement of interest or relationship as the grounds, then the Attorney General, the district attorney may be able to withdraw, but the Attorney General doesn't have the authority to make that appointment. And our position is that in this case, Mr. Durden has provided a letter to the Attorney General stating basically that he doesn't have the resources. Well, there's lots of ways for prosecutors to address those resources, and those are not addressed. The legal grounds of interest or relationship are not stated. Now, the district attorney's office, and I'm not in the Cobb County District Attorney's Office, or District Attorney Pro Tempore, kind of like a search warrant situation, they may well contend that there could be additional reasons that are not stated. Now, my understanding from speaking with Mr. Durden is there are no such reasons. But certainly the state would want to have the right to present them if they existed. But under the statute, which is very clear, interest or relationship are the only reasons that allow the Attorney General to appoint another one. Second point here is, and of course, this is all uncharted territory, and we certainly want to have the ability to preserve that issue for appeal, maybe even interlocutory appeal, depending on how the court rules. We also have the issue here of the failure to comply with the statute. When the Attorney General makes that appointment is to be filed with the clerk of the Superior Court. It is to be copied to the Chief Judge of the circuit. It is to be provided to the counsel or the parties, if they're unrepresented, who are affected by the appointment. That appointment, by the documents submitted by the District Attorney's Office, that appointment dates back to May 11th. The paperwork was not filed until June 8th. And the argument is, and it's an open question of law, Your Honor, and we can see that there is no case law on that point. The question is whether those provisions are mandatory or they are directory. In other words, whether that's a requirement or whether it's optional. Because if it's a requirement, all acts taken by this district attorney prior to the filing of those documents were illegal. And that raises a whole host of problems with the indictment, with the preliminary hearing, all the events that took place, all the actions taken by the Cobb County District Attorney's Office prior to the filing. And those may or may not be curable, but we're far from getting to that point. But the point I'm making to the court is you've got the two issues. One is whether under the statute the Attorney General had the authority to change the prosecutors in this case. And second, if they had that authority, is that authority effective before they comply with the provisions in the statute? Our contention is that those are mandatory, not directory. The filing and the provision of notice is not a suggestion. And the reason for that, Your Honor, is the district attorney is in fact a constitutional officer, and we don't have star chambers in the state of Georgia. We don't have secret prosecutors and secret things that people don't know. Every citizen of Glenn County, not just Mr. Bryan, every citizen of Glenn County, every citizen of Cobb County should be able to tell who the prosecutor is for felonies in that jurisdiction. And when the Attorney General makes secret appointments that don't comply with the statute, then it creates, and I'm not saying anything improper took place here, but it creates an environment that is not conducive to public trust and confidence in our judiciary. And therefore, our position is that those requirements are mandatory and not directory. And for both that reason and the fact that there were no grounds to make the appointment, as a matter of Georgia law, the district attorney lawfully appointed to prosecute this case is Tom Dermott, whether he wants the job or not.
From the state, again, I'm trying to just work through whether we need to have an evidentiary hearing or whether this is a question of law. That being the case, from the state.
Thank you, Your Honor. This is a question of law, Your Honor. It is an attack on the statute. It's an attack on the AG's office. And it's wordplay. This basically says 15-18-5, appointment of substitute for absent or disqualified district attorney. Section A, when a district attorney's office is disqualified from interest. Interest can be taken one of two ways. I have an interest in the case, meaning it's going to affect me personally, financially, familially, with family, something along those lines. The other way it can be an interest is, as we have under the Georgia Rules of Professional Conduct, Rule 1.7, a lawyer shall not represent or continue to represent a client if there is a significant risk that the lawyer's own interests or the lawyer's duties to another client will materially and adversely affect the representation of the client, and that's what we have here. I will submit to the court State's Exhibit Number 10. I've shown that to Mr. Goff. This is the letter from Mr. Tom Durden. Any objections, counsel?
No objection.
Okay.
Let's figure out how to shuffle documents around here.
I don't need to look at it, I already have.
Mr. Durden's letter speaks for itself, that he does in fact have an interest that disqualifies him. He is the elected official for the Atlantic Judicial Circuit. 6 counties, only 11 assistant district attorneys, and 3 investigators. And in that letter, it indicates he was more than happy to take this matter on, but he didn't know what it was and how large it was and how many resources in his office it was going to take up. When he discovered this, he did the right thing, because he is representing the people of the state of Georgia. And not only...
I just want to make sure. 10 was admitted.
Thank you, Judge.
Go ahead.
He was representing the people of the state of Georgia, both in the Atlantic Judicial Circuit, to whom he has a legal obligation to make sure that he can do what he needs to do to prosecute the crimes in that circuit. He also has an obligation to the people of the state of Georgia in the matter of the death of Ahmaud Arbery. And when he realized that he had taken this on voluntarily, that he did not have the resources to do this, he went ahead and disqualified himself based on his own interest, which is his interest in providing good services to the people of the Atlantic Judicial Circuit and also to the people of the state of Georgia in this particular matter. So while defense counsel wants interest to only be one thing, interest is more than one thing as it falls under the Rules of Professional Conduct 1.7a. Going behind Mr. Durden and questioning him by putting him on the stand and going, well, what were you thinking? What were you doing? Actually violates attorney-client privilege. His client is the state of Georgia. And going behind and going, well, why did you do this and what were you thinking and could you really have done this? He's basically saying, I have a conflict and I have to be taken off this case. The Attorney General's office does not go behind a district attorney, an elected official, a lawyer, and go, no, you don't really have a conflict. They take the elected official's word, here's your reasoning, you have a conflict, and I have to go ahead and assign it to someone else. And in this particular case, the Attorney General's office did that. They received Mr. Durden's letter, and they appointed Cobb County District Attorney Joyette Holmes as the District Attorney pro tempore, State's Exhibit number 11. I'd like to tender State's 11 at this time.
Mr. Scott.
No objection.
Submitted.
And Your Honor, Mr. Goff is completely correct. That was brought, that letter went out May 11th of 2020. And he's absolutely right. I failed to file it. It's on me, totally on me. I'm the one, when it was brought to my attention after speaking with the Attorney General's office, they said, you know, you're up in Cobb and there's no way for you to file into this case. There was absolutely no way for you to electronically file into this case prior to the indictment. They said, okay, you need to figure out a way to make sure this gets filed because, Ms. Dunikoski, you cannot walk across the street to the courthouse. You're up in Cobb County. So I called the clerk's office and I said, you know, I need to get this filed. I need to make sure it hasn't been filed yet. And I will take the hit on that because it did not get done in a timely fashion. It got done by June 8th. Not because the district attorney's office was going to try and hide that they'd been appointed to this, but because of the technicalities of the electronic filing system that Glenn County has. And that is the reason for that. There was no star chamber here, and in fact, once this appointment was made, I'm sure we'll be able to find numerous video clips where Mr. Goff was talking about it on the news. The reason you file this in open court is to make sure that opposing counsel knows that the district attorney has changed and that service now for anything should be on a different district attorney. He was informed of that and was well aware of that on May 11th. So that is not actually an issue. The real issue here, Your Honor, is that this Mantooth case and the Nellis case, N-E-L-S, both stand for the proposition that a defendant does not get to select his or her prosecutor. This is the state of Georgia versus William Bryan. If William Bryan was sued civilly, Mr. Bryan would not get to go, oh, Mr. Johnson's suing me. I don't like his attorney. She's too good. She's too smart. She's got a great team. I want a different attorney representing the person who's suing me. That is not how this works. And in the state of Georgia, a prosecutor is a prosecutor is a prosecutor, except if they have a conflict. And in this case, Mr. Durden did in fact have a conflict. The Attorney General, when he received that notice, did what the statute requires him to do, which is to go ahead and appoint someone else. There is absolutely no law that the defense can point to, no statute that the defense can point to, that gives a defendant a right to challenge a district attorney saying I'm disqualified off the case. In this case, it appears that Mr. Bryan didn't like Mr. Durden's choice. Oh, well, he could have done this, he could have done that, he could have gone ahead and brought in somebody else or asked for something else. That's not the defendant's choice. He doesn't get to tell the district attorney how to run his or her office. There's absolutely no standing here for him. In addition, as the court I'm sure noticed in Mantooth at the very end, it also pointed out that the court had absolutely no authority in that case whatsoever to grant or deny any sort of challenge. That there is nothing that provides this court authority to question the district attorney who makes that decision, nor the Attorney General who goes ahead and respects that elected official's decision to recuse themselves and appoint someone else. Thank you very much.
Sure.
I'll try and be brief, not my long suit, but I'll do my best. First of all, Your Honor, this e-filing story is, with all due respect, utter nonsense. I'm not implying that anybody has evil intent or malicious intent here, but let's be clear. We had a preliminary hearing in this courtroom 4 days before the paperwork was filed. Ms. Dunikowski was here and present all day for that hearing. And 2 days prior to that hearing, a motion was filed, or a pleading filed, putting the DA on notice that there was a question about whether there was a proper appointment. So the idea that some e-file technical issue was the reason why it wasn't done, well, that's just not true. So to the extent that it causes the court concern, I think it justifies a hearing. Beyond that, the real issue isn't Mantooth or Nels, because they really don't, they're not squarely on point. They're certainly the Court of Appeals. None of the issues I've raised today are actually directly addressed in either of those decisions. The state contends that the defendant does not have the right to select his prosecutor. Now that is undoubtedly true.
We agreed on something.
We agree on that. We may have an objection to a particular one or the manner in which they're appointed, but we don't get to pick. At the same time, Your Honor, the victim doesn't get to pick the prosecutor either. And this is a case, literally, of national importance. Everyone from the President of the United States on down to the janitor seems to have opinion about this matter. And we are now our fourth prosecutor. And two of those prosecutors, as I understand it, are under investigation not only by the state law department, but by the United States Department of Justice, supposedly, over the manner and how they got in and out of this case and what they were doing when they were in it. So I think under those circumstances, I do believe we're entitled to a hearing. And to be fair, Mr. Durden has come down here today. He's prepared to testify on this subject. So is Mrs. McGowan. I meant her no disrespect. This issue is going to get addressed at some point, and I would humbly suggest that we address it now. But if the court doesn't want to do that, I mean, the court has all the power, but I'm going to suggest in the case of national importance where so many questions have arisen about the prosecutors in this case and how things were handled in this case, that in this case, above any other case that's been in the Georgia judiciary, this is a case where any question as to the propriety of an appointment or how it was done should be addressed thoroughly, openly, on the record, as early as possible. And that's what we're asking you to do today.
All right, well, here's where I'm concerned on the standing issue. The issue, and I get back to whether or not this court in this setting has the authority to go in and address a challenge to a claim of conflict of interest by a district attorney under these circumstances. I'm going to leave the standing issue alone. As to the conflict itself, there is nothing in the record indicating that the way the Attorney General was notified of the conflict was inappropriate. I've gone through the bar rules, and just gleaning what I can from Mr. Durden's letter, there's no indication that the attorney was not complying with the rules when he wrote the letter. As to the AG's decision then to move forward and appoint Ms. Holmes, I understand the argument. I have the appointment document dated May 11th. There is no argument in the motion, and I have heard no argument with regard to prejudice or surprise. I don't believe that that is an issue before the court. And under those circumstances, the court, we're not going to move forward with a hearing, with all due respect to those individuals who, although they may be here, and the implication is they're more than happy to provide that testimony. My understanding is these folks were either subpoenaed or told they would be under subpoena. and they're complying with court process. Being officers of the court, they'd be required to do so anyway. So whether those subpoenas were served, unserved or not, they're here because they believe that they were material to this case based upon representations made to them. This court's position is these are questions that can be addressed without a full-blown evidentiary hearing. The court is denying the motion to strike the illegal appointment of Ms. Holmes as District Attorney Pro Tem. I'll go ahead and enter a written order on that. It'll probably be sometime early next week.
Thank you, Your Honor.
Thank you, Your Honor.
The final matter then the court has before it today, as properly noticed, would be the amended motion for bond filed on behalf of Mr. Bryan dated June 24th, 2020. Is the defense ready to proceed on that motion?
We are, Your Honor. We have been conferring with Mr. Evans, I believe, is handling this motion for the state. There's two aspects to the motion. One is the standard 1716-1 conditions under which the court can grant bond. And we have presented by way of exhibit a number of statements from family and friends on behalf of Mr. Bryan. We have one witness to testify briefly on that subject. As indicated in our amended motion, pursuant to the ADA guidelines and previous directions of our appellate courts, we believe that this is the case where the court can and should consider the substantive strengths and weaknesses of the prosecution in this matter. And we've discussed that, and there's the long way of doing it, and there's the short way of doing it. And unless the court has an objection, I think our proposal is both sides are going to tender their exhibits that are relative to the substance of the case itself. And rather than playing a bunch of evidence or reading, the transcript from the preliminary hearing at length, submit those and let the court review them and decide what the court is willing to consider and needs to consider and whether it impacts the decision of the court. If the court's inclined to grant bond, there's no reason to go into that. If the court doesn't care what the strengths or the weaknesses of the case are, that may not matter. So rather than spend hours trying to go through that process, I think if we take a 5-minute recess, we can probably agree on the exhibits to be filed rather than played or presented here. And we can either argue that issue now, or the court can direct us to file briefs on that subject. In which case, our bond hearing would be relatively short and relatively traditional, but we would have the record there if it was important to the court. And given the state's response to the motion, I would think it might be. So, but whatever we agree with doesn't really matter. Ultimately, it's what the court wants to do. But there are 4 or 5 videos. We don't have all the videos. We're not going to get into that today. We thought there would be more evidence here than there is, but there's enough. And we're prepared to go forward. And that would be my suggestion. We're not here in front of a jury. The court can well decide what evidence it wishes to consider under the fairly relaxed rules of a preliminary hearing. And if the state's comfortable, I'm comfortable, the court will consider the evidence that it deems relevant and will not consider the evidence it doesn't. If it's not referenced in the court's order, I'm going to assume that the court considered it, neither found it not persuasive or not relevant. In which case, we can probably be done within the hour, maybe half an hour.
Sure.
Your Honor, I will be handling this motion, and I will tell the court the state's ready to go forward. The exhibits that the state intends to introduce in as a responsive matter are here in the courtroom, and they've already been furnished to both the defense, and I believe copies have also been furnished to your office per your directive from us. So all of those exhibits are now pre-marked and sitting here on my table. We'll be ready to tender those at the appropriate time in response to the defense motion for bond. So we're ready to go forward with that. And if there isn't any objection to it at that time, I trust the court will receive those for the appropriate purpose. I will, however, tell the court that I don't believe that the strength of the case has anything to do with the considerations before this court today. And because of that, that might impact the admissibility or the relevance of certain evidence that I know the defense wants to put in, namely some videos that they brought in this morning. And since that is not a factor to be considered in a bond consideration, I would object to them being admitted for that purpose. I know that that is one of the things that defense counsel has alluded to.
Well, ultimately, whatever the court does, we want them proffered. In the event that we file an appeal of the court's decision on the bond, should that be necessary, we would want the proffer, so it would be part of the record to take up to the appeals court. But the authorities are cited in the motion, and they're not new, and they're not novel.
Maybe I'm not hearing correctly, but I was under the impression there was some sort of agreement.
I thought there was. I'm not sure there is.
And I'm not suggesting there should be, there is, but I just heard two completely parallel, non-intersecting explanations about what we're going to do. So, we're dancing around the issue of evidence. It's a scope issue from the sounds of things. A bond hearing is not a place where we try a case. I'm not trying the case today.
We're not sure. But
So what are we getting at? I don't really, you're talking about the strength of the case. There's some motions filed by the state objecting to certain, and I haven't gone through all of the evidence, but objecting to certain evidence, which under the Georgia rule seems a little questionable to begin with.
well, Your Honor,
So I'm wondering what we're getting into and what we're referring to, because what I'm not going to do is have a bond hearing where the doors are thrown wide open to evidence in the case, admissible, inadmissible, or otherwise, under the pretense that we're talking about the strength of the case. So, again, we're on parallel tracks. So, why don't we take a short recess and the two of you talk about what exactly the two of you just told me, because it didn't make a lot of sense to me. If you can reach an agreement about something, stipulate to it, present the stipulation, and we'll move forward. If we can't, then we'll address the bond motion, and we'll address any objections to any presentation of evidence associated with the bond motion. Do both of you understand my instructions?
yes, Your Honor.
Okay.
And I would humbly suggest, I'm sure the court read it at some point, that to review the authority cited in the amended motion number 5.
Mr. Goff, we're not trying your case today. We've already had a 7-hour preliminary hearing. I've read that transcript. I'm fully aware of that evidence. So we're not going back over all of the preliminary hearing matters, as well as retrying the case in the context of a bond hearing. If you've got issues specific to bond, then so be it. I'm aware of the authority, but the authority isn't try your case on the day of the bond and then just kind of see how the chips lie. That's not what we're going to do here today. So if there's evidence that you wish to present, that there's an objection to, now's an opportunity for the two of you to talk about it. If there's no stipulations reached, we'll see what the status of that conversation is and what we have to hear today. But I'd like to get into the bond hearing. So we're going to take a 10-minute recess, and I'll come back on the bench and hear what y'all plan to have me do.
Thank you.
Just trying to make sure.
Yeah, okay. So I gotta do that one. Okay.
What's wrong?
Now, Doyle, here, go back to the.
See.
Thank you.
Okay. We are back on. Defendant's present. Mr. Bryan, can you hear me?
Yes, sir.
And you can see me?
Yes, sir.
All right, we're back on then. Again, everybody's present.
Your Honor, we've resolved most of the issues with respect to the evidence, bearing in mind that whether the court considers it to what extent will be up to the court. But in to review those, with the court's permission, I'm going to approach sidebar, or the jury bar. We are consenting to the admission of states 1, 2, 3, 4, 5, 6, 6A, 7, and the unnumbered statement. Oh no, that's not going to be tendered. That's just a demonstrative, I guess. Your Honor, we are consenting to that, to those. In fact, some of those are exhibits that we had intended to present ourselves. We have defendant's composite exhibit 1 that was attached to the amended motion for bond. The state has no objection to those. We wish to present what is composite, would be composite exhibit 3, which is 5 of the videos from this case. The state has reviewed those. I think they're objecting, so that'll have to be addressed. The state consents to exhibit 4, which is the incident report, not the full police report, but the incident report from the day in question. And the state objects to what are marked as exhibits 14 and 15. Those are certified convictions of the alleged victim in this case. So we have, of all the exhibits that both sides intended to present today, we have 3 that we would like to discuss with the court. And since they're my exhibits, I guess I would go first. And I will take these back to the council table so I can discuss those.
Okay. Mr. Evans.
Judge, I'm certainly appreciative of the court giving us opportunities like this to discuss things, to see what clarity we can provide to the court. And I sincerely hope the court realizes that I'm not trying to in any way create gray, and I don't think that I have. I tend to be a law and order sort of linear kind of person, Judge. You strike me as somebody that's sort of like that too, very linear in approach to things. I think perhaps the disconnect here is that normally we have an opening. If there's an opening, the defense will present its evidence. This has been my experience with bond hearings. The state would either object or not object to it. I've already told counsel for the defendant what I would be objecting to. In fact, I actually did so in writing with a response to pleading in objection to certain character evidence. So that was done in advance of this hearing. There are admittedly certain items once they're presented where I don't think the state's going to object to them because there's at least an arguable basis for why the court might want to look at those. And then I've also provided, well in advance of this hearing, a number of exhibits that the state intends to tender at the appropriate time, unless you tell me that that time is now, that as has been articulated by defense counsel, he doesn't intend to object to once we've talked through those things. So that's where we are in the process, is that that's what's been going on behind the scenes even before we arrived down to Glenn County from Cobb County. And I do agree that there's probably going to be some exhibits that are tendered at some point, whether that's now or during the course of a bond hearing, that probably are not going to be objected to. And there is also going to be some victim impact testimony and a statement that Ahmaud's father has asked that I read to the court. So that's where we are from the state's perspective regarding the matters now before the court. And I think that that summarizes what I thought the procedure would be with a bond hearing, as is normally the course of a bond hearing as they're handled in at least our judicial circuit. If you instruct the state or the defense to do otherwise, we of course will abide by the wishes of the court, and we'll be ready to go in whatever fashion you deem fit.
You and I, we took a 10-minute recess, figure out what we could agree on. I thought we had, and now I guess I'm confused. The court has already indicated the court's reviewed the preliminary hearing transcript, and it's a state exhibit and a defense exhibit. We're going to use the state's copy because it's a better copy than I was able to make at home this morning. And our position is that we address the 3 exhibits that there's an issue about, and that brings us down to 1 5-minute witness for the defense and 1 probably 5-minute witness for the prosecution. And that seems like that will be a whole lot simpler than spending an hour or 2 going exhibit by exhibit when we're basically in agreement as to all the 3. And I'm pretty confident that...
Well, here's the challenge for the court, right? Is unless I have a stipulation that the parties have entered into, I don't have any stipulation. And what one party may think is an easy, more or less time-consuming way of addressing a matter may be seen completely opposite by the other party. What I'm hearing is that there's an agreement on most of these exhibits. We still need to hear it.
Well, we can go ahead and stipulate to the admission of the ones that we can stipulate to, and then we'll address the rest during the hearing.
Yeah, but that's what I thought we were going to try.
Well, I mean, yes, I think we're there, and we're going to go ahead and tender.
Well, let's do this. Hold on. Let's take it back up. Burden of proof is on the defense. Burden of persuasion is on the state. As to the burden of proof, Mr. Goff.
All right, at this time, if I would understand the stipulation, we're going to tender states exhibits 1, 2, 3, 4, 5, 6, 6A, 7. I think those are the numbered exhibits. Am I correct?
So, Judge, again, I'm not trying to be difficult. Those are state's exhibits, and I have no problem tendering them. If you're telling me now is the appropriate time, then we'll make that tender. I understand there's no objection to them, so I'll tender the exhibits. There's no need for the defense to tender my exhibits.
States 1 through 7. I want to be clear for the clerk.
Yeah.
Where's my clerk? There you go. 1 through 7 are admitted. That's state's exhibits.
Thank you.
Your Honor, at this time, we would tender States Exhibit 1 and 4. 1 is a composite exhibit of character statements for the defendant, and 4 is the incident, not the full Glenn County Police report, but just the incident report from the day in question, the day of the shooting.
I'm a stickler for the record. I just admitted 1 through 7, I believe.
Yes, those are S 1 through 7.
You want to go?
Let's hold them there for just a second.
And we're now tendering D1 and D4.
Okay, I think you referred to them as states 1 and states 4. These are D1 and D4.
I still sometimes do that. And we'll just leave those there.
Any objection from the state?
No, not as to those 2 exhibits.
D1 and D4 are admitted.
At this time, Your Honor, we would tender composite D3. It's not marked. If Madam Court Reporter will help me with a sticker. I'm not sure how well they stick to these things, but we'll do our best.
easier to just throw it in an envelope.
And I probably should have thought of that before I got here. My apologies. If Madam Clerk has an envelope, I will be happy to borrow it. Well, borrow's not the word. I probably won't return it.
I'll remind counsel that's government property that he's borrowing and not returning.
Unfortunately, Mr. Evans doesn't have jurisdiction over that offense. And I'll put this over here. Your Honor, and now that it's been properly marked, it's already been shown to opposing counsel.
Mr. Evans.
Your Honor,
Sorry, you tendered it. Is there an objection?
There is.
Mr. Evans.
I object to it based on relevance in that it doesn't go to the issues that are framed for bond. I was told during a break that these video clips, which are contained on this flash drive, are being proffered to the court regarding the issue of strength of the case. And under Georgia law, I'm aware of no legal principle by which that should be a pertinent consideration for the court as you pass upon the issues of bond, which are codified and also encompassed in the IL case.
and Your Honor, if I may briefly respond to that. First of all, Your Honor, the Georgia statute 1761 E2, the court shall consider any other factor the court deems appropriate. So the consideration of that exhibit is consistent with the statute. Moreover, as I pointed out generally earlier, Georgia courts of law look to the ABA standards for pretrial release, for example, Lane v. State, and those ABA standards expressly reference consideration of the apparent probability of conviction. And in fact, I suspect Your Honor, in rare cases over the years, has in fact considered that in deciding whether to grant a bond or not. Other states, of course, have codified that. Now, in this case, my suggestion is that this is admissible simply for the rule of completeness, because the court has already read the preliminary hearing transcript in this case, as we would have asked if we had been asked. The court already has reviewed 274 pages of evidence in this case, specifically the testimony of Agent Richard Dial about the contents of these videos. While they're not referenced by exhibit number, when the court is reviewing that transcript, the court is hearing the officer's testimony as to what he observed on these videos. The content of all 5 of these videos is explicitly referenced in the preliminary hearing. So all we're asking the court to do, having already heard basically a full day's worth of testimony by way of transcript, is we're asking the court to allow us to append to that information the court has already accepted the actual videos, most of which are short, so that they're available so the court can independently assess the credibility of the testimony of the affiant, Richard Dial, in deciding whether to grant bond in this case. Having already heard his testimony and his testimony referencing these exhibits, we think it's appropriate for the court to be able to actually look at the exhibits themselves and not simply rely on his opinions. So we believe under the circumstances, for all those reasons, that Exhibit 3 is appropriate. And whether the court admits it or not, we want to follow the record as a proffer in the event that this matter winds up going on appeal.
I don't believe I've got anything further to add for the court. I think I've simply stated the basis of the state's objection. We stand by it. We just don't think that the strength of the case is really the controlling factor that the court needs to consider as you pass upon the bond in this case.
I don't want to get into what's on the videos, but I don't know what the videos are of. What are we talking about?
If I may, Your Honor, there is a video.
Just to be clear, I don't want to editorialize on the videos.
Yes. Your Honor, there is a video from outside the English residence on the day of the shooting. There's a video from the inside of the residence on the day of the shooting. It is an excerpt because the full video is, to our knowledge, only in the possession of the state. But the excerpt is sufficient for purposes of the hearing that we have today. There is the video of the shooting itself. It's not a complete video, but it is complete enough, and the court has probably already seen it on television anyway. That video is on there, well, it's like 90 seconds. And there's a video of previous instances where the alleged victim entered the same residence, or what appears to be the same person, entered the residence on other occasions, including the incident where there was an encounter between Travis McMichael and Mr. Arbery. It is referenced specifically in Agent Dial's testimony. And am I missing one? I think I've got them covered. But these are videos, they're all relatively short, and they're all specifically referenced in the preliminary hearing testimony that your Honor has already heard. And I would try to suggest to Your Honor that you're going to try and rule with the fiction that you haven't read it. You've already read it, you've already heard the evidence. This is simply providing impeachment, if nothing else, because the video and the testimony of the agent don't track each other.
So I'm going to go ahead and admit it. I'm admitting it with a very clear statement that I have not done so based upon ruling that the strength of the case is in fact a determinative factor with respect to bond. I'm admitting it. We can take a look at the cases and make sure. Apparently, I've got a number of exhibits I'm going to have to take a look at before I can rule on the bond issue anyway. So I'll take a look at the strength of the case issue along with that. I think the four factors are what we need to focus on, which is again why the court did not want to get into effectively trying this case today. With that explanation, Mr. Goff.
Thank you, Your Honor. Exhibit 14 is a certified copy of the conviction for Mr. Arbery for the offense of theft by shoplifting, for which he was on probation at the time of his tragic death. And we are tendering that because it is relevant to the claim of the state that Mr. Arbery was justified in assaulting Travis McMichael in this case, understanding that Mr. Bryan's liability here is largely derivative of the conduct of the McMichaels on the day in question. If their conduct was in fact justified and Mr. Arbery's conduct was not justified, then with all due respect, there's no case against Mr. Bryan either. And I would refer to the court, I'm not going to argue this twice, but I have on file a pre-hearing memorandum of law regarding citizen arrest, which addresses the appropriate authorities, and this conviction goes...
Which is one of the things that was filed last night, correct?
I had thought I had served it on the state earlier, but maybe not, but I did file it last night. But the law, nevertheless, hasn't changed, and I suspect the court probably knows that law better than I do.
The only reason I raise that, I don't think it's fair to anybody to start getting into issues. I saw the memorandum of law filed. I don't think we need to get into this issue yet. Let's address the specific exhibit. I understand you're claiming that it's associated with that particular legal issue.
In my argument, when the evidence is finished, I will be addressing those issues in context of this exhibit. We contend that the knowledge of Mr. Arbery as to what he had done in his past are relevant to whether his actions were objectively justifiable, and therefore the shoplifting conviction would be relevant to whether he had reason to believe that he was subject to citizen's arrest for his conduct. And that is 14 and 15 is a certified copy of conviction. That is for carrying weapons within school areas without a license and multiple counts of obstruction of a law enforcement officer. I believe that's a felony obstruction. And we believe those are both relevant to the assessment of whether or not Mr. Arbery was justified in attacking Mr. McMichael, whether Mr. McMichael was justified in defending himself. Those turn on Georgia's unusual law with respect to the right to resist arrest, as well as stand your ground. So these are admitted because they reference objectively what Mr. Arbery knew about his situation on the day in question. Mr. Arbery knew what he did, and Mr. Arbery knew what he had done in the past. And that is relevant to whether or not
We're now going,
I made my point. I think
well, let me be clear about something. Yes, the court's not going to be used as a vehicle to try the case outside of the court.
Yes, sir.
You understand the court's instruction?
Yes.
All right. So before we start getting too far in argument, I want to hear from the state, because the state has objected to the evidence, as I understand it, based on the character of the victim. And your argument, as I understand it, is this is what the victim was thinking at the time that this occurred.
This is what he knew.
Okay. Mr. Evans.
I do object to the admission of the evidence. I did file a motion regarding that objection involving the limited purpose of what we're here to deal with today. Regarding the factors that this court must consider under OCGA 17-16-1, those exhibits have absolutely nothing to do with defendant's burden of showing that he poses no significant risk of flight, that he poses no significant danger to person, community, or property, defendant's burden of showing that he poses no significant risk of committing a new felony, and finally that he poses no significant risk of intimidating witnesses or obstructing justice. They bear absolutely no pertinent, relevant information as to those factors, which are, of course, what this court must consider when assessing the issue of bond. Furthermore, they establish nothing regarding defendant's roots in the community, his length of residence in the community, his employment status and history, his history of responding to legal process, or defendant's criminal history. And for those reasons, Judge, there's a valid basis for the state to object to the admission of those evidence, items of evidence, as they currently have no bearing on the issues that are before the court when it comes to considerations and matters of bond.
Honorable Mr. Evans.
Your Honor, if Mr. McMichael was justified in defending himself against Mr. Arbery's assault, then there is no case against my client. That's not a weak case. That's no case. And that is obviously important. I don't like necessarily the Georgia law on any of these subjects, but we deal with the law that we have, as Your Honor does. Mr. Arbery knew what he was doing that day. He knew what he'd done in the past.
Judge, I need to object.
Yeah. Go ahead. How do you know that?
Mr. Arbery is on the video, so we know what he did. And Mr. Arbery was there.
The objection is sustained. Okay, it's not going to.
Well, we're still proffering them. We want them part of the record, even if they're not going to be considered by the court.
You can proffer them as part of the record, but they're not going to be an exhibit in the bond hearing, other than the fact they're not going to be considered as part of the bond hearing.
I understand. Well, I'll just give these to the clerk.
All those courts 1.
Court 1 and Court 1 and 2.
I'll just do it. Court 1 and 2. Mr. Jones.
We have one witness to present this morning, Your Honor, and that is Preston Ryan or Preston Kelly. Ryan. Your Honor, that's our first witness. Sir, if you'll come forward.
So every jurisdiction does it a little bit different. I take it that the court generally here in Glenn County will swear the witness or the clerk. Okay, we'll get the clerk to this one.
Please raise your right hand. You solemnly swear or affirm the testimony you shall give the court shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do. Thank you.
Sir, would you please state your full name for the record?
My name is Preston Roger Kelly Bryan.
Now, what is your relation to William Roderick Roddy Bryan?
He's my father.
And how long have you known?
For 26 years I've been alive.
Very good, sir. And although it is unsigned, I believe you did submit a statement. on behalf of your father?
Yes, I did.
All right, and that's part of composite one, Your Honor. Sir, I have a few additional questions I need to ask you, okay? If your father were to be released on bond, would he pose a significant risk of fleeing from the jurisdiction of the court or failing to appear in court when required?
No, he would not. He would be there wherever he needs to be.
Do you know whether your father poses a significant threat or danger to any person, to the community, or to any property in the community?
He does not.
Do you know whether your father poses any significant risk of committing any felony pending trial?
No, he will not.
Do you know whether your father poses any significant risk of intimidating witnesses or otherwise obstructing the administration of justice?
No, sir, he will not.
All right. As I understand it, your father has lost his home?
Yes, sir.
Are there other family members in Southeast Georgia, without disclosing addresses, where he would be able to live?
Yes, sir.
And if he were to be released, do you believe he'd be able to find other gainful employment?
Yes.
All right. Are you asking the court to release your father on a reasonable bond, bail pending trial?
Yes, I am.
Thank you, sir. I have no further questions.
Anything from the state?
Thank you. Very briefly, defendant is your father, correct?
Yes, sir.
And fair to say that you're here in support of your father, accurate?
Right.
And you wouldn't want to see anything bad happen to your father, correct?
No, sir.
If you needed something from your father, for example, he could call upon you, and just as you testified here today, you would be there in support of him, correct?
Yes, sir.
I know that you have a relative that lives in Costa Rica who's pretty close to your family. Who's that?
My ex-stepmother.
Okay, so your ex-stepmother lives out of the country, correct?
Right.
You're aware that your father remains in close contact with her by text and otherwise, correct?
Right.
You're still in contact with her too?
Not really.
And you had mentioned that you don't believe your father's the risk of committing a new felony. You're aware of the charges that have been currently levied against him by the state of Georgia through the Glenn County Grand Jury, correct?
Yes, sir.
Okay. They include malice, murder, and other crimes, correct?
Right.
I want to ask you about some testimony that you gave here on direct. It's accurate that your father has lost his home, correct?
Right.
And he's currently unemployed.
Yes, sir.
Doesn't have a job as we speak, right?
No, sir.
Can you please articulate for the court what real property, like real estate, does your father have in the state of Georgia that would could be put up as collateral for a bond? What real estate does he have currently?
I'm not sure of what he owns.
Okay. You can't articulate for the court that he owns any real property in the state or in Glenn County?
No, sir.
All right. And then in terms of financial means, please identify for the court any real thing of value that your father currently possesses that could be used as collateral if the court were to issue some sort of bond. What would be used as a basis for assisting in the posting of that bond?
I'm sorry, Your Honor, that's a multiple question. I'd ask you.
I'll break it up. Your father doesn't own any real things of significant value that could be used as collateral for the bond, correct?
Ever since he went to jail, he does not have anything.
He doesn't have anything in terms of
That I know of.
valuable property that you're aware of?
Exactly.
Okay. His only ties currently to Glenn County are the fact that he may have some family members that happen to live here. Is that accurate?
Yes. He worked here most of his life.
Sure. Can you please identify for the court any relative or friend that you have that lives outside the state of Georgia? Or let me say that, of your father's that lives outside the state of Georgia. We'll break it up. You got relatives that live out of the state?
No, sir.
Okay. You got close family friends that live outside the state, your father's close family friends?
He does not know.
You're not aware of any of those?
That I can think of. No.
Yeah, so there was a question that was posed about whether your father would be getting a job if he were released from custody. What job specifically is that you're referring to?
He'd probably go back to being a mechanic on lawnmowers and small equipment.
Got it. So when you say probably go back to that, he doesn't have a job pending or anything like that as we sit here now?
I can think of two places that would probably hire him back.
Again, probably, correct?
Yes, sir.
All right, thank you, sir.
Any reason?
Yes, Your Honor. Sir, at the time your father was arrested, he was in fact a homeowner, was he not?
Yes, sir.
And as a result of his incarceration, he's lost his home.
Right.
At the time that he was arrested, he owned a car.
Yes, sir.
And he's lost that as well.
Yes, sir.
And he had a job at the time he was arrested.
Yes, sir.
In fact, your father was gainfully employed as a mechanic for many, many years, was he not?
Yes, sir, for 20, 32 something years.
Through no fault of his own, he's lost those things due to his arrest.
Yes, sir.
But you testified that he is capable and able and willing to work, and that there are people that you believe would hire him if they had the opportunity to do so.
Object to leading.
It's sustained.
And you've indicated that, well, I'll rephrase. Do you know whether other family members have real property and other assets that they would be willing to put up to post bond for your father?
Yes.
Do you know whether your father has friends that would be willing to put up property and other assets to secure a bond for your father?
Yes, he does.
Do you have any doubt that your father, through friends and family, would be able to post a bond in a reasonable amount in this case?
No, he shouldn't have any problem.
Okay. There was some reference to an ex-wife living in another country.
Right.
Has Mr. Ryan ever visited that country?
Yes, we visited there before when they were still married. We went to Costa Rica and spent Christmas
Since they
there.
got divorced, how many years ago was that?
Just about 4 years ago now, 5 years ago.
Since they got divorced, and since she remarried another man, has your father been to Costa Rica?
No, sir.
Do you know whether your father even has a passport right now?
I do not know.
Do you know of any reason why he would object to surrendering any passport that he might have?
No, sir.
And in this COVID era, is there any reason to believe he could leave the United States if he wanted to?
No.
Does your father speak any other language other than English?
No.
Does he speak Spanish?
No.
Okay. So, is it practical for him to try and live somewhere else?
No.
If Mr. Bryan, if your father was placed under house arrest, do you have any reason to believe he wouldn't comply with that condition?
He would comply.
If you were aware that your father was not in compliance with a house arrest condition, would you report that to the court?
Yes, I would.
All right. If the court were to impose an ankle monitor on your dad, on Mr. Bryan, do you have any reason to believe that he would attempt to thwart that device?
No, I would not.
All right. If you became aware that he was attempting to thwart that device or defeat it in any way, would you promptly notify the court or law enforcement or whoever the district attorney's office would direct?
Yes, I would.
And if the court were to impose a curfew, likewise, do you have any reason to believe your father would not comply with the curfew?
He would comply.
And if you were aware that your father was not in compliance with the curfew, is there any reason why you wouldn't promptly notify the court or the district attorney's office or whoever would be appropriate?
I would.
Now, you have a number of other family members, many of whom have made statements to the court here today in support of your father. Do you have any doubt that these individuals, including his sister, his fiance, and others, do you have any doubt that they would promptly notify the court or any appropriate authority in the event that your father violated either an ankle monitor provision, a house arrest, or curfew restriction, or other restriction imposed by the court?
No doubt that they would all comply.
Are you asking the court to release your father under the least restrictive conditions that will assure his appearance and compliance with the orders of the court?
Yes.
Thank you, sir.
And recross on those limited issues.
I mean, if he was released on bond, are you saying that he'd be living with you such that you could report these things to the court?
He would not be living with me, but he would be living with family.
Okay, so those questions then about what you might report, then your knowledge, that would be limited because you weren't actually living with him. That's not the intention, correct?
Well, if I had to deny him, I would go live with him, yes.
All right, thank you, sir.
I have no further questions.
All right, thank you, sir. You may step down. Any additional witnesses or evidence from defense?
No, Your Honor.
Mr. Evans?
I have the evidence before the court. I do want to present some victim impact evidence before the court as well, pursuant to the Crime Victims Bill of Rights. So in addition to the 7 exhibits that have been presented here, I want to point out that Mr. Arbery's father is here in the courtroom. Would you just stand up so the court can see where you are, Judge? And he's asked that we share his sentiments. Thank you, sir. You can have a seat with the court. Just 1 second, Judge. It was emailed to me. I'm going to find it real quick. Kristen? You have your phone? And thank you for submitting that to you. Because we're remote, Judge, this sometimes makes things a little bit complicated from our perspective. This is from Ahmaud's father. I suffered the deepest loss a family can endure. When the McMichaels, with the knowing participation of William Roddy Bryan Jr., acted as my son's judge, jury, and executioner, I urged the court to reject the motion for bond and continue to keep Mr. Bryan behind bars and to maintain District Attorney Joyette Holmes as the prosecutor on the case. That's his short statement that he asked to be shared with the court, and I did provide that to defense counsel as well. Thank you, Ms. Burke.
And we have no objection to that.
And then it's my understanding that Mr. Arbery's mother wishes to address the court. Is that accurate? Okay. So I'll call her as a witness so she can give a short victim impact statement as well.
You want to read from her here, or?
She's not, it's just the impact statement itself.
It is.
Mr. Goff, any objection to the impact statement?
No objection to the victim impact statement, but I believe she's being sworn. She will be subject to cross-examination if we choose to do so.
I don't think that she needs to be sworn for a victim impact statement. I probably don't have an objection to her being sworn, but I don't think that's required. It's merely a victim impact statement.
What are we getting into, Mr. Gardner? You're going to ask her about the statement?
Your Honor, if it will facilitate the hearing, I'll waive my right to cross-examine her.
All right. Let's go ahead and just take it as a statement into the record, as a victim impact statement.
Yes.
You come forward.
Would you prefer she use the podium?
Yeah, it's probably easiest to do that. We're just going to
So first, if you will, introduce yourself to the court. State your name.
My name is Wanda Cooper Jones.
And Ms. Cooper Jones, Ahmaud Arbery was your son, correct?
That is correct.
Do you understand what we're here for today? We've talked to you about the fact that the defense is seeking a bond for this defendant, correct?
Yes, sir, I understand.
And in advance of this hearing, we asked if you wanted to address the court regarding that issue. Have you prepared a victim impact statement regarding the issue of bond in this case today?
Yes, I have.
Would you please share that with the court?
Thank you. William Roddy Bryan conspired with 2 other men to kill my youngest son. I named him Ahmaud Arbery. I raised Ahmaud on my own in this small community of Brunswick. Ahmaud was loving. Ahmaud worked extremely hard to provide income for our household. Also, Ahmaud also worked hard to be physically fit. Mr. Bryan does not deny getting into his pickup truck and chasing my son. He does not deny blocking his pathway. He does not deny recording the murder of my son. He does not deny being within feet of his co-conspirators as my son was called a racist name as he laid on the ground before passing away. He does not think there's anything wrong with what he did. He wants this court to allow him to go home. I am asking this court to say no. He cannot go home. He did not allow my son to go home. My son ran away. My son actually ran around him, and my son actually ran for his life. But William Bryan did not allow my son to return home. So I stand before you as the mother of Ahmaud, asking this court to give Mr. Bryan the same energy that he gave my son. There is not enough evidence to establish this unrepentant man in being a danger to this community. He lived just feet from where my son was murdered. I lived just miles away from where my son was murdered. I'm actually scared, Judge, to stay inside of my home. I've actually put my house up for sale. I often visit the location where my son was killed. And each time I visit there, I fear running into either three of the men that murdered my son. Because William Bryan does not feel he did anything wrong, what is it to say to stop him from doing this again? He must remain in custody. He's dangerous, he's unapologetic, and therefore I'm asking this court to keep him behind bars.
Thank you, ma'am. Absent any inquiry from the court, we appreciate you sharing your words today.
Thank you.
I believe that completes the evidence that the state wishes to present regarding these narrow issues.
Burden of proof on the defense. Mr. Goff.
Your Honor, this is a serious case in the eyes of the nation or upon us today, upon Your Honor. And that's a heavy burden. I'm glad you have that job. But the law is very clear, and there are no conditions set forth by statute that my client hasn't met here. There is no evidence that he poses significant risk of fleeing from the jurisdiction or failing to appear. There's been no evidence whatsoever. There's no evidence whatsoever that he poses a threat or danger to any person in the community or to any property in the community. The state hasn't even tendered a criminal history because it's incredibly minor. And there are no prior felonies and no previous offenses of any severity of any kind in a nearly 50-year life. And there's just utterly nothing presented to suggest that he poses that threat or danger. There is no evidence, not a scintilla of evidence before the court, that he poses any significant risk of committing a felony pending a trial, nor is there any evidence whatsoever, not even a scintilla, that he poses any significant risk of intimidating witnesses or otherwise obstructing the administration of justice. Those are the legal standards, and we have met our burden, and the state hasn't even begun to meet theirs. He would certainly be entitled to a bond. Now, this is a murder case. People get bonds in murder case when they meet the statutory criteria, as Mr. Bryan has in this case. And, you know, it's important in the way we conduct these proceedings that we maintain confidence in our criminal justice system. And when people who wear badges in other high-profile cases get OR bonds,
Object to
it's
the
relevant
relevance of
that.
That's sustained. Let's address the case that's before the court.
We would submit, Your Honor, that Mr. Bryan is entitled to a bond, notwithstanding the fact that this is a murder case. Just like any number of other defendants have been granted bonds in murder cases in Glynn County, in Chatham County, and elsewhere.
Simply not relevant, and I would object.
The court's already ruled on it. Again, we're addressing the facts and circumstances of this case. What may have happened in another case that this court is unaware of, facts and circumstances and so forth, there's no relevance to what's going on before the court currently. Let's stick with the burden that is placed upon the court. in this particular case?
Well, as I've addressed, there isn't a scintilla of evidence to suggest that the defendant doesn't meet all four of the conditions set forth by statute. But beyond that, Your Honor, there are the facts and the strengths and weaknesses of this case. And I'm not going to repeat at length the arguments that were previously made at the preliminary hearing. I know the court's already read the transcript. But as a general proposition, it doesn't matter how many counts the state files. The same problem adheres to all of the charges against Mr. Bryan. Mr. Bryan was not in communication with the McMichaels or anyone else that day prior to the shooting about what was going on. He has had, as a matter of law, no knowledge of any unlawful intent, if there was such unlawful intent on the part of the McMichaels. He cannot conspire to do something unlawful when he is unaware of it. He cannot conspire to intentionally aid and abet people in committing a crime when he's unaware of their purpose. That's not opinion. That's undisputed, uncontradicted fact. You don't need the polygraph. Agent Dallas testified. That's what their investigation shows. The investigation shows that Mr. Bryan was unarmed at the time of the offense. You know, we talk about witnesses and intimidating witnesses. Your Honor, Mr. Bryan is the only eyewitness in this case, other than the McMichaels. He is the state, whether they like it or not, he is in fact the state's star witness. If he had not made the video in this case, there would be no case. And notwithstanding the false narrative that has been painted, it is utterly absurd to think that there was a lynch mob or a posse running around to the shores in 2020. It didn't happen. And whatever was going on between the father and son, Greg and Travis McMichael, my client doesn't have any knowledge or awareness of any unlawful purpose. He can't have such knowledge. And he doesn't have such knowledge. So it doesn't matter how many counts there are. It doesn't matter how you spin it. The state cannot meet the mens rea element. This is a directed verdict all day long. And there's no way around that for Mr. Bryan. McMichaels, that's a different story. And I'm not here, I'm not their lawyer. I'm not representing them. They have very capable counsel for that. But from my client's perspective, there is no case against Mr. Bryan.
I have to object. It's not pertinent. It's not an argument regarding directed verdict or an argument to a jury. We're here to focus, as I understand it, on the limited factors that this court must consider to bond. It's not relevant.
I understand the argument. Again, we're not trying the case here today. I understand that there are defenses that will be raised.
I do specifically want to address issues raised by the mother of Mr. Arbery. I think I'm entitled to do that.
Well, it's unsworn testimony. That's a victim impact statement.
But if the court considers it, I can...
Let me finish. I'll give you all sorts of opportunities to talk. Give me an opportunity to talk. It's a victim impact statement. It's not being considered by the court as evidence. It was unsworn. It's simply the mother of the victim stating her position on bond. As to the facts from that witness, again, unsworn statement, the court's not going to be considering those facts. The court is considering simply the statement itself, as well as her position with regard to bond. The basis of her position needs to be weighed by the court based upon what is actually competent evidence before the court.
Thank you, Your Honor. And directing Your Honor to the preliminary hearing transcript that's been admitted evidence and Exhibit 3, the videos in this case, we respectfully submit that the narrative that has been put forth at times is incorrect. It has been suggested that Mr. Arbery was simply jockeying while black.
We're not getting into that. Again, her statement is her position as the mother of the victim. The evidence that you're about to get into, we will have more than enough time to address. There is a disagreement, clearly, between the state, your client, and the McMichaels about the facts and circumstances of this case. This is not the time for that. There's a disagreement. We're not going to resolve that today, which gets back to this question about the strengths and weaknesses of the case. We're going to try the case eventually, and that's where we're going to determine ultimately where this case plays out. for the purposes of bond, whatever the defense believes the evidence shows, we're not going to get terribly far into it, as I've indicated. I've heard the preliminary hearing. There was a lot of cross-examination. In fact, that was one of the longest preliminary hearings I've ever seen. There's a lot of evidence in the record. So the court's familiar with the disputes between the parties over the timelines and the evidence that's out there. So we don't need to get into that now.
Your Honor, based on that, I'm not going to regurgitate the pre-hearing memorandum of law regarding citizens' arrest and the authority cited therein. I trust at some point the court will review those. Your Honor, I think it's also important to recognize here that the legal landscape has changed a lot in the last few months. We're operating in a public health emergency. Jails and prisons here and around the country are riddled with this virus. And for some people, that's a death sentence. And Mr. Bryan is presumed innocent. And I can't cite a particular case Your Honor has addressed, but all around the state of Georgia, we have been granting people bonds partly in recognition of the fact that the dangers are exceptional and extraordinary. And we're asking the court to consider the fact that my client is, I think he's close to that age to be in a high-risk category. He has other health issues that place him in a risk category. And we think that in this case and in this current environment, that the court can take those matters into account. Even in violent cases, courts have taken those matters. In serious cases, courts have taken that into account and granted bond where ordinarily they might not. And in this case, of course, I haven't seen the scheduling order yet. I mean, we'll see that soon enough. But unless we prevail on our challenge to the Supreme Court's judicial emergency order, we're looking at a situation where there may not be any jury trials until May or June of next year. Mr. Bryan could be incarcerated for 18 or more months before we could have a jury trial, maybe longer than that. So in this situation, given all of the circumstances, as well as the evidence in this case, and the lack of a record, and the lack of any evidence whatsoever to the state to question whether he meets the qualifications for a bond, we are asking the court to grant him a bond under such circumstances, and in whatever amount the court deems appropriate, whether that's surrendering his passport, if he has a passport, whether that's house arrest, whether that's an ankle monitor. If the court's concerned about where he would stay, we don't want to put that in the open record, but we certainly can provide that information in confidence to the district attorney, the court, and the sheriff. If he needs to, he can stay with his son, but there are family members who reside outside of Wayne County. We are sensitive to the concern of the Arbery family that they not be running into people associated with the case. And there's no reason that Mr. Bryan cannot remain and be banished from Wayne County pending the resolution of this case. So all of this, as far as I can see, all of the legitimate issues that the state would have in this case have been addressed. And we're asking the court to set bond for Mr. Bryan in a reasonable amount.
Thank you, Mr. Jones. Mr. Evans.
Thank you, Your Honor. I'm going to limit my remarks to the state of the law regarding this issue and then the evidence before the court, or maybe even some of the evidence that's not before the court. So for purpose of our record, you correctly noted, Judge, that the burden of proof falls upon the defendant. That's Dunn, D-U-N, versus Edwards, 275, Georgia, 458. It's a 2002 decision. Defendant must produce evidence as to each of the four Ayala factors. Ayala is A-Y-A-L-A. I believe your court reporter probably knows that. And I'll cite Constantino versus Warren out of Cobb County in that proposition. C-O-N-S-T-A-N-T-I-N-O. Warren is common spelling. 285 Georgia 851. That's a 2009 case. The state admittedly has the burden of persuasion. You can find that in the Constantino case. And then I do want to point out an important fact here, which is why some of the state's documents become pertinent, that the defendant is not entitled to a bond as a matter of right on felony offenses where he's indicted in a timely fashion within 90 days of his arrest. I'm sure the court is aware of the state of that law. You can find that not only in Constantino, but it's also codified in OCGA 17-7-50, which stands for the proposition that the defendant, if we exceed 90 days and he hasn't been indicted, might be entitled to bond on certain offenses, but not all of those offenses, depending on what the indictment looked like. So now getting to the factors that the court must consider, some of those factors would include evidence of defendant's roots in the community, length of residence in the community, his employment status and history, which is suspect as we stand here now, history of responding to legal process. There's really been no evidence presented by the defendant as to that. And then admittedly, as to criminal history, there's not much of one for Mr. Bryan. He may have a DUI or something like that. But he certainly started off with a bang for this one. OCGA 17-16-1 is where you can find the codification of the 4 factors that you must consider. The evidence must be presented by the defendant, and a course shall be authorized, note the key word authorized, to release a person on bail if the court finds that the person poses no significant risk of flight, poses no significant danger to persons, community, or property. Number 3, poses no significant risk of committing a new felony. And finally, poses no significant risk of intimidating witnesses or otherwise obstructing justice. I'm sure the court is keenly aware of those 4 factors. Of note, the failure of defendant to carry its burden as to any one of those factors is a sufficient legal basis for this court to grant your discretion. It is a discretionary function as we sit here right now to deny defendant's request for bond, and the state would urge that you do so. There are a number of reasons for that. So let's go through some of the pieces of evidence before the court that I trust you'll be considering. The purpose of tendering State's Exhibit Number 1, the arrest warrants, is for showing the court the date of the arrest. That warrant was issued 5/21 of 2020, initially charging the defendant with felony murder and criminal attempt to commit false imprisonment. The upgrade obviously came with the indictment, which is State's Exhibit Number 4. It was issued 6/24 of 2020, so well within the 90-day period. So the purpose of showing that is to, again, show the court that this is a discretionary function. I'm pleased that the court read through State's Exhibit Number 2, the preliminary hearing transcript. Certain facts that I'm going to reference have nothing to do really with the strength of the case, but bear mention because of the 4 factors that you must deal with. What you'll see on page 31 is the defendant and his co-defendant saw the victim. Defendant said, "You got him." That's 31 and 32. The evidence shows that defendant participated in chasing the victim, an unarmed jogger, on public streets through a protracted chase, and that it lasted minutes. That's page 47 and 251 to 52. When it comes to danger of committing felonies, these facts bear directly on that issue and that factor that this court must consider. There's been some argument that the defendant might not be a danger. There's questions that were raised about firearms. I will point out on page 34 through 36 that defendant used a truck against a man running on a road. I think that certainly goes to the fact that this man is a danger to the community. He did take video of Mr. Arbery's flight and evasion. That's on page 38. Nonetheless, defendant chose to use his vehicle as a weapon, which bears consideration as you pass upon whether he's a danger to the community. We now have an added part that came since the indictment, and that is going to be a GBI report, which is State's Exhibit Number 5. It shows that this defendant's vehicle was used to strike Mr. Arbery, and that there was a dent that defendant acknowledged was on the truck because of his contact with Mr. Arbery. And then since the probable cause hearing, State's 5 confirms that we have victim Ahmaud Arbery's palm print on the side of defendant's truck. And as was testified to during the preliminary hearing, victim was essentially quote-unquote trapped on page 57 and 63. That again goes to the dangerousness. In terms of obstruction of justice and those concerns, I'll point out, as revealed in the transcript, defendant did not call 911 as he began this chase. He also says, or claims, page 31 to 32, quote, "He didn't really know each other." Nonetheless, after he and his co-defendants were arrested, they had contact with each other. And that was testified to in States 22 and 255. It's confirmed in captured call detail 6A, which shows the McMichaels having attempted contact with this defendant after this murder, and despite his claim that they didn't really know each other. One of the co-defendants actually refers to the defendant as an ally in a recorded jail call. That's on page 66 to 67, which goes again to the obstruction factor I would submit to the court. The full phone report involving call detail is State's Exhibit number 6, and then the pertinent phone calls extracted from that are labeled now as 6A, showing the contact between these co-defendants after the murder but before the arrest. And then State's Exhibit number 7, I would really ask the court to take consideration of in light of a important exhibit that we've put before Your Honor, and that's State's Exhibit number 3. State's Exhibit number 3 is a press release regarding the Civil Rights Division of the Department of Justice, the FBI, and the United States Attorney's Office from the Southern District of Georgia. They confirmed that their case is under investigation and that federal charges are under consideration. I can't confirm whether or not that decision will ultimately be made in the affirmative or not, but State's Exhibit number 7 is particularly telling. We have a number of text communications that were extracted from this defendant's phone, and they are replete with racist and bigot remarks and communications, which goes directly to the risk of flight and concern that this defendant might pose a risk once the Department of Justice has time to digest this. Repeatedly, this defendant uses the N-word, a term that I had to look up, bootlit, talks about monkey parades, working like an N today. There's just a ton of filth in this defendant's text regarding that. And that's of particular note in consideration in light of the very public fact that there might be additional forthcoming charges, not just the indicted charges at the state level here. We think you should consider that, Your Honor, as you pass upon these 4 factors and whether this heightens the risk that we might have flight on the part of this defendant. So now getting to those factors and meshing sort of the facts before the court and that law, we believe that there's evidence the defendant poses a significant risk of flight. As indicted, he's facing not just 18 months that speculatively he might be held upon prior to trial. By my calculations, he's facing potentially life without the possibility of parole, plus at least 27 and a half years. That's a significant amount of time and the most serious charge that could be levied against the defendant in the state of Georgia. There are texts to support the DOJ's investigation. I've revealed this to Mr. Goff, and he knows that we talked about it on the phone. I can confirm as of yesterday that the GBI has opened an additional parallel investigation into sex crimes that's stemmed from this. So that confirmation came by the email yesterday. I say that to say that this now also heightens the risk of flight as well, and Mr. Goff and I did discuss that. The conditions are certainly not improving for the defendant, and we are very concerned that he's got connections outside the country, connections to Costa Rica. In fact, the text messages you'll see, Judge, some of those communications with a person outside of Costa Rica, they're listed as Costa Rica, so it'll be easy for you to look at, Judge. They're just days before this murder. As to prong number 2, poses significant danger to persons, the community, and the property. The facts alone that I've articulated, particularly the pertinent facts, show that this defendant participated in the chase, corralling, and murder of an unarmed man using a truck as a weapon. And we think that those facts alone show that he is a danger to the community, and that should weigh heavily against bond as this court passes upon him. As for posing a risk of committing a new felony, I agree that the GCIC or criminal history is limited here, and that's why it wasn't tendered for the court. Should the court need that at some future date, I'm sure we'll decide whether to tender it or not. But that doesn't tell the entire sordid story of this defendant. Things have changed with the DOJ investigating and the confirmation that the GBI is investigating a further unrelated offense, but an offense that arises from our investigation of this case. And then the last factor, poses no significant risk of intimidating witnesses or obstructing justice. Defendant's referred to as an ally by his co-defendants. That's before the court. And while defendant minimizes his connection to his co-defendants, phone records reveal continued contact, and that evidence is before the court too. Where it basically seems to show that there's kind of a circling of the wagons with these three defendants, at least after the murder, but before the arrests were made. As for the allegation regarding the pandemic in the jail, first of all, I wanted to say, since the opportunity presents itself, how appreciative I am of the court. We are of the court, taking added precautions to make sure we're all safe today. And I want to again publicly say, we want to say that we are confident that the Glenn County Sheriff's Office is doing an incredible job maintaining our safety, maintaining social distance where feasible, requiring masks when people are not talking, limiting the number of people in the courtroom. Those things to me certainly suggest that if there's a sheriff capable of protecting the safety of people in the Glenn County Jail, it's Sheriff Neil Jump. And I feel confident that issues regarding the pandemic will be adequately addressed at that jail. Certainly they've demonstrated in this courthouse that they're cognizant of these things. I'll also note for the court that I see no factor that says because we have a pandemic, it's a wholesale time to start setting people charged with murder out on bond because there's a risk they might be getting sick. Probably a good argument that being in a controlled environment is maybe even a safer place at this time. I don't know the answer to that because I haven't talked to the sheriff about his numbers there, but I'm confident that he's taking the needed steps to protect the inmate population there. Judge, I point out that any one of these four prongs is sufficient basis for this court to deny bond. The state's presented evidence as to each of them. You need only find that one has failed, that the defendant's failed to carry his burden as to any one of those prongs. And I've just articulated arguments to the court as to how the defendant arguably fails on each of these through the state's exhibits in the current situation. We've provided not only argument, I've now given evidentiary support as to each of these prongs, and it is within your discretion to deny bond. The fact of the matter is the defendant's not entitled to bond. He was indicted with considerable effort, I might add, in extraordinary protective measures, and we did so within 90 days because of the gravity and seriousness of this case, and quite frankly, what the national impact has been in terms of riots and things like that. And it's for that reason that we were able to fashion a carve-out or avail ourselves of a carve-out to the grand jury limitations so that we could make sure for the betterment of the community in this particular case that we were able to get that indictment in a timely fashion. That puts this court in a good spot in terms of your consideration of bond because you're not required to grant bond on this case on any of the counts or otherwise. That's not a portion of the law that the defense could avail itself of, and I think you know that those timetables have been suspended anyway. Nonetheless, out of abundance of caution, the state wanted to demonstrate for the benefit of the court and the community that we're committed to the fact that we're going to move this case forward in a timely fashion. And if we're trying this case in 18 months or 6 months, the state will be ready. And I trust that at the first available opportunity in considering your scheduling order, when it's feasible to talk about a trial, we'll get to that point. I can also assure the court that when it's time to try this case, whenever that may be, probably is not going to be the state that's going to be the delay in getting it to trial. We'll be ready when we get reached, and that's certainly something that I can commit to the court as you consider this bond issue. Bond is discretionary. This defendant's not entitled. Quite simply, you should deny bond.
Mr. Galfano.
Your Honor, we're not going to begin to address charges that have not been made by other entities. If the Justice Department wants to bring charges, if they believe that they should do that, they will. And Mr. Bryan can address whether he can get bond at that time in that court. This court is also quite capable of revoking the bond if additional charges come from some other source. As to these other matters, again, if I had died every time a prosecutor said something else was going on out there and it never materialized, I'd be a rich man. If there's something else out there, it'll get addressed at that time. We're here addressing this case now. The suggestion that my client, a mechanic with a high school education, is going to flee in this COVID environment to another country, Costa Rica. I don't know whether he's going to swim or how that's going to happen, but I think that even if the court let him keep a passport, it's still utterly unrealistic to think that a citizen of the United States is going anywhere right now out of this country. And the fact that his ex-wife that moved there years ago and remarried another man, that she is going to facilitate that, the state has presented no actual evidence to suggest that. Basically, what it all comes down to is a long, elaborate version of the dog ate my homework. The standard justifies the court, authorizes the court to grant Mr. Bryan a bond. And we believe, given the problems with this case, which are, without belaboring the point, are fairly obvious, and the likelihood that one or all of these defendants will be acquitted at trial, and given the delays that are associated with this virus and the risks to everyone involved, and specifically Mr. Bryan, we believe it's appropriate and the just and right thing to do to grant Mr. Bryan a bond. The court is certainly capable of fashioning, whether it's house arrest, curfew, ankle monitoring. There's many different ways the court can assure itself that Mr. Bryan will be here. And again, as far as intimidating witnesses, Your Honor, there are no witnesses to intimidate. The number one witness in the case is Mr. Bryan himself, whether he intended to be or not. This isn't like some mob case where we're going to go out and we're going to rub out somebody. This isn't that kind of case. You read the preliminary hearing transcript, and I find it hard to believe the state would suggest that even if some diabolical mastermind wanted to arm somebody to advance their position in case, this just isn't that case. So the state hasn't met that burden, and we're asking the court to grant Mr. Bryan.
Thank you. All right, where do we go from here? Let's see. It's 1 o'clock. At a minimum, I'm going to need to take a look at those documents. To your credit, a lot of that has been submitted to the court, or at least referenced, so I'm familiar with chunks of it. I do want to make sure that I haven't had an opportunity to digest what's actually been submitted. And I think, based on the running start we have at it, I can do that over lunch. And so I think at this point, the best way to proceed, because the other option is to simply figure out how to get that evidence back with me, review it, and get a written order out. I think this is a case that would probably just warrant taking a look at this over lunch, making sure I'm clear on what the evidence is, and reconvening so that there's a definitive ruling today, as opposed to everybody waiting over the weekend. So that's a long way to be saying, we're going to break for lunch. I'm going to take a look at the evidence over the lunch break. It is 1 o'clock. Let's try and reconvene at 2 o'clock. If for some reason it's taking me longer to get through what I need to, or I'm otherwise delayed, I'll notify everybody at 2 o'clock. Any questions from the state?
No, Your Honor.
From the defense?
None, Your Honor.
All right, then we'll be in recess until 2 o'clock. Yeah, let's go to
All these?
including